25th, 2025 meeting of the St. Louis County Land Bank to order. Purpose of this meeting is to conduct the business of the board. And you may proceed with roll call.
Mr. Trimble, Ms. Dancy,
Here.
Ms. Jordan,
Here.
Mr. Lance,
Present.
Ms. Grant,
Present.
Ms. Warren,
Present.
Mr. Shugab, Ms. Vice Chair, you have a quorum.
We have the minutes of the board meeting from September 12th. Is there a motion to approve or any discussion?
Also move.
There's a second?
Second.
All those in favor?
Aye.
Aye.
Need the motion to approve the board meeting minutes from September 12th.
Abstain since I wasn't there.
Noted. New business, we have a presentation today by Rachel Waterman from the Legal Services of Eastern Missouri. And we'll go ahead with Rachel's presentation that we've all been looking forward to.
Oh my gosh, thank you. Well, I'm excited to see two new faces. Nice to meet you guys.
Meet you too.
I'll let you, Rachel, oh shoot, I didn't mean to do that. Move the faces around as you so desire. Okay. Everyone see the presentation?
Yes,
Yes.
I can see it. I don't know about everybody.
Okay. You wanna put the one over so that everyone's face shows up?
That's what I thought I was doing,
Oh, and then it just.
and then it just went big again.
Maybe. Larger or something. Besides.
But I think the only one missing is the view of the room.
Oh,
So
okay.
this is
So I
actually,
can see it.
yeah.
All right, well, I hope my presentation lives up to expectations. And please stop me at any time and we can make this as conversational as possible. And then if there's anything I don't cover that you guys have been curious about, I can try and answer anything. The reason I'm considered the subject matter expert is because our office helped draft the state level legislation and the county level legislation that enabled the existence of this amazing land bank board, which I could not be happier to see coming to fruition. The main thing I'm going to talk about today is the county's tax foreclosure system. Unfortunately, very unfortunately, you cannot do your job as land bank board members without an intricate understanding of St. Louis County's tax foreclosure system. And now systems, there's not going to be two of them. And that is the way by which the land bank primarily will be acquiring property. So there's this link between tax foreclosure and land banking that is entirely how land banks get their property across the country. So that will be primary topic and then some other things thrown in there, but just, again, feel free to stop me at any time. And it kind of, I started off real basic. This presentation has been done so many times, so some of it might be too rudimentary for board members, but it's gonna be that part. Okay, it's not, oh, I'm sorry, doing anything. Is the land bank a public entity? So you guys are a quasi-governmental entity that can take title to tax delinquent properties that don't sell at a public tax auction. Also take title to other properties by other means, but that's the primary way, taking title to properties that don't sell at a public tax auction. The task of the land bank is then to get those properties out of the land bank. Contrary to the name, banks hold things. A land bank does not actually want to hold these properties forever. That's not what you're looking to do. You want to maintain them, market them, get them out of the inventory to people who will put them to good use. New responsible developers, owners, public use, whatever, or decides is a good use. Okay, so a very basic sort of pathway of an abandoned tax delinquent property to the land bank. You have the abandoned property, the county performs the tax foreclosure process. Properties go to a public auction. The opening bid at that public auction is going to be the total tax debt on the property, plus any fines, fees that have accumulated throughout the foreclosure process. The tax debt is the base level, and then usually 100 to 1,000 gets tacked on through legal fees and late fees and everything else. Bids, if no one bids on the property, it automatically transfers to the land bank. At that point, the tax debt is cleared. So there's zero tax debt after that, once it enters the land bank. Land bank takes ownership. Their job is to maintain the property and find a developer. Easy. Okay, next. Should I be?
I'm sorry,
Where are land banks most useful in any geographic area with inventory of vacant tax delinquent properties that have been difficult to return to productive use? So if you have a really strong market, people are gonna find a way to get those tax delinquent properties back to productive use. In situations where that's not happening, that you need that land bank to kind of push the market forward. Barriers to redevelopment of abandoned properties. Unpaid tax debt and other liens, so taxes are not the only liens on these vacant properties. The property conditions, of course, they're deteriorated and they only get worse once the property is vacant. Quality of title, so that is sort of related to liens and other issues, but whether there's clouds on title that are gonna prevent a title insurance company from issuing a policy, that's gonna be a barrier to redevelopment because we can't get money without title insurance.
I may just, for the record, Chicago's joined us.
Okay, so the final one is surrounding market. How does the land bank respond to these? Unpaid tax debt and liens, the judicial foreclosure process, which is what the land bank will be connected to, eliminates all tax debt and liens except federal. So state law cannot trump federal liens. There are different processes for federal liens that are, the federal government will consent to removal of its liens under a judicial process much more than it will under an administrative process, which is what the county currently uses. But base level, the process is going to clear the majority of liens from the property. Property conditions, the land bank is free to invest in properties that it owns once it owns them. So St. Louis City Land Bank has actually done some programs where it puts on a new roof, puts on just, does a little bit of shooting to the property in order to attract buyers. And if you have the budget for that, it can be a great type of program. Bundle properties to attract buyers. Someone might not want to buy one property on a block that's struggling, but if there's 5 that the land bank owns, you have that sort of advantage of scale to attract buyers. Quality of title, land bank is going to have clear, insurable title. Majority of the time.
Can you go back to the first bullet point and
Yes.
explain the judicial foreclosure, how that eliminates all tax debts?
Yeah, and that would be much more in depth later, but the basic concept is that if no one issues the minimum bid for the tax debt and then it goes into the land bank, government doesn't pay taxes, so it's considered eliminated forever by entry into a public entity, the tax debt. The other liens are cleared because those lien holders got notice and an opportunity to redeem. And if they didn't choose to redeem the property from tax sale, they lose out.
But they do have the right to redeem.
Exactly. So a mortgage company can pay the tax debt, keep their property out of tax sale, do whatever they want with it. The government is the only one that has that tax lien, which is different from all the other liens. That's eliminated by entry into the land bank.
Thank you.
Surrounding market, land bank can concentrate its investments, improve market conditions. Again, that advantage of scale. Land banking is a 2-step system. Step 1, tax enforcement. Step 2, land banking. Tax enforcement is the how, what happens to an owner when they don't pay their taxes. Land banking is the where. Where does the property go if no one buys it at a tax auction? Okay, here's where we start getting into the details of the law. There are 2 chapters in Missouri law related to tax foreclosure that apply to the entire state. There is a 3rd chapter. It applies only to St. Louis City, so I'm not even going to discuss it here. Chapter 140 and Chapter 141, those have both been on the books, 140 for ages, 141 for 10 to 20 years now. Chapter 140 is what St. Louis County uses now. Chapter 141 is only used currently by Jackson County for the Kansas City Land Bank. Chapter 140 is a tax lien auction. The property itself is not being auctioned off by St. Louis County. They are auctioning off their lien. You can buy our tax lien and attempt to collect. Or if they do not pay, then you, the tax lien buyer, basically execute a private foreclosure of your tax lien that you bought from us. So the county is not doing the foreclosing, it's more akin to selling the right to foreclose. Chapter 141 is a tax title auction where the foreclosure is done by the county through a judicial system so that in the end, there is a deed auction where the buyer buys the deed at tax sale and they immediately have title to the property. St. Louis County is now a partial opt-in county. That was step one. Before you can have a land bank, you have to become a partial opt-in county, meaning it can now use both systems. So it can choose. Are we using 140, system we've always used, or are we going to use 141, judicial system that until now has only been used in Jackson County? The two buckets where properties end up at the end of these systems, currently, everything that just doesn't sell in 140 ends up on the post-third list. Now, if a property goes through 141 and doesn't sell, it will go to the land bank. So that's your pipeline of properties, anything that goes through 141. You have a universe that's going to go through 141, that we'll talk about how that universe gets created. A portion of those are going to get redeemed. People are going to come pay their taxes. They won't go to tax sale. Another portion will go to tax sale and get purchased by bidders at auction. And then it's the leftover portion that will go to the land bank.
Do they all have to go to the land bank, the leftovers that go through 141?
Obligatory title transfer to land bank if there is no bid at auction under 141. So that's why the key part is thinking strategically about what properties should go through 141, because if they don't sell at auction, the land bank has to take title to them. It's also the reason that St. Louis City and Kansas City have struggled so much with their inventory is they are not a partial opt-in. Every single tax delinquent property goes through their judicial system and they're forced to take title to every single property that doesn't sell. That's how you end up with 12,000 properties in your inventory, because every single property is going through this obligatory pipeline. County has a huge advantage now because it doesn't have to take everything. It can strategically acquire in the land bank inventory so that you don't get bogged down by thousands and thousands of properties.
Rachel, I know through all the various discussions we've had all these many years, we've always said how important it was not to get too many properties into the land bank, that it, especially initially, to start slowly. So we need the collector, with whom does the board of the land bank work to at St. Louis County? What are the roles that the assessor and the collector play here? And what we do need a plan or a thoughts to how we work with them and integrate them into this whole process.
Yes, so the state level law says that when you become a partial opt-in county, decision between which properties go through 140 and which properties go through 141 rests with the collector. So it just says the collector decides, because the law applies to all of Missouri. There are very few officers that every county in Missouri has. Collector is one of them. So St. Louis County is subject to the same thing that the rest of Missouri is. The collector decides. So the collector will make a list of which properties go through 141. St. Louis County collector, or DeVore, has no appetite to make that list. He will be expecting to get a list. And basically my understanding is he'll just rubber stamp the list. So that list presumably will come from the land bank board or some combination of stakeholders. The land bank board in partnership with council people, the executive, community stakeholders can work together to assemble this list. That list is given to the collector. The collector says, great, this is the 141 list for this year. That happens annually.
So there's no advantage to the collector just to dump a whole lot of stuff into the land bank, or do you see any kind of potential for a problem there? I mean, we haven't really gotten the buy-in of the county collector into this whole process, to my knowledge.
Be very skeptical that the collector would choose 141 of his own volition because it's much more expensive for the county. The county has to do a lot more work when it carries out the 141 system. That costs money, so they're not gonna do that unless there is some sort of incentive or ask from a higher up to do that.
Okay, all right.
Unless Mark DeVore goes rogue, I don't know. Did that answer that, Joan?
Yeah, it's, I hadn't realized that, but again, I guess my point, I've got a lot of background noise, I'll mute just here in a minute. The, the sooner, I guess, that we start coordinating with the collector and others, stakeholders that, as the land bank board, probably the better. I'm gonna mute myself here because of the background noise.
Can't even hear your background noise, so no worries there. But yes, and I've been in meetings with the collector, the council people, folks from the executive who are invested in making this process work recently. There's a couple moving pieces. They understand that a whole new process has to be implemented. Right now, money for that is a question mark. We've applied for Missouri Foundation for Health funding that would be used by revenue in order to carry out this 141 process so that there's at least a pool to start with. They could also work with the land bank. You guys have $1 million. You could pay for the process to the extent that the revenue won't. They can find money to pay for the process. But they do know that they need to do it. And then we'll talk about the parts of the process. They can contract out, like they don't have to do the 141 process in-house with their own staff. They can contract with local experts who run this type of business to do the process. So let me just keep moving.
Can properties that went through 140, like in the like the next calendar year, can they go through 141?
Yes, anything that's at any stage of 140 could get plucked from 140 and start 141. We have to make sure it gets cleanly plucked from 140, like erased off all 140 lists, which can sometimes be a little complicated because there's a lot of layers of 140. But yes, definitely.
And you don't get to 140 until after the third attempt to auction.
140, you don't start getting auctioned until 3 years of delinquency. And then there's a 140 first auction, 140 second auction, 140 third auction, and then post third. But at the whole time you're considered within the 140 system, or I guess I would say you're considered in the 140 system at the point of first auction. That's it.
When would we see it? We would see it the first.
You, the land bank?
Yeah.
You, the land bank, shouldn't or wouldn't or don't need to see anything in 140. Like it would be a clean rate unless, like Maud is saying, you chose to pluck something out of 140. Otherwise, we just have this universe of tax delinquent properties that no action has been taken. And then there's a point at which you decide, okay, we're gonna take 140 action or we're gonna take 141 action.
I guess I'm thinking about the original owner's ability to recapture.
Yep.
We have to wait until after the third attempt, or is that at any time?
The original owner's ability to like pay their taxes
Yes,
and
pay
take
their
it out of
taxes.
auction. We hold on that one. I think I'm gonna answer it.
I have a question, Rachel.
Yeah.
You mentioned, Missouri Foundation for Health
Uh-huh.
and applying for funding.
Yes.
Can you, like, give an overview of what that funding is for
Yeah.
and who's applying for it?
So Legal Services of Eastern Missouri, Center for Community Progress, who have you guys heard of them? I'm sure they've been mentioned. They're the national experts on land banking. County of St. Louis and City of Springfield put together a joint application for funding in which we, the two legal services providers, if you think of Center for Community Progress that way, would be funded to provide technical assistance. So like I could keep getting paid to do stuff like this and provide support to both the land bank board and the county as needed, technical expertise. Center for Community Progress could do that for Springfield. And then the money that was applied for on behalf of those two local governments was for the 141 process. So funding that could pay for the steps of the 141 process for a hypothetical bucket of 100 test properties. So like 100 tax delinquent properties, what would it look like to put that first batch of 100 tax delinquent properties, instead of putting it through 140, putting it through 141. And the local governments also asked for a staff person in-house who could help coordinate this, because it's a whole new system. Ideally, at St. Louis County, there would be coordination between problem properties and people who are on the ground actually looking at problem properties all the time. Revenue, who's the one who needs to see is stuff tax delinquent, executive, council, all the stakeholders who have an interest in making this work, having a staff person dedicated to making it work. So there's one staff ask at both Springfield and the county.
So, okay,
But we haven't heard if we're getting that funding.
sure,
Follow up?
yeah.
Yeah.
So the technical person would be a technical person that, when you say the county, you're referencing this county body, or you talking about county government?
County government, so separate
Gotcha.
from you.
Gotcha.
Yeah. So it wouldn't be direct money for the land bank, it would be money for county to do their process.
Gotcha.
So it is a confusing truth that you guys are quasi-governmental, but you rely completely on the county to do a process that will feed properties to
Sure.
you.
Okay.
Right, but you are not county executive governmental body. Right. Why use 141 if it's more expensive and more work? Greater certainty because you're getting a deed and not a lien. More insurable title because those liens get cleared and it ends up in the land bank instead of going to post third, which many people could speak to as some form of purgatory for properties. Investors might be willing to bear the costs of the uncertain outcomes and title issues in a strong market, but they're going to be much less willing to do that in a failing market. That's where the land bank wants to operate. Okay, so here's how 140, the county's current system, plays out calendar-wise throughout a year. The spring, the collector makes a list of 3+ year delinquent properties that will be listed for sale in August. That's the first time those properties get listed for sale. And I say properties, but what I really mean is the tax lien gets listed for sale. In June, the owner will get a regular piece of mail alerting them that the property lien is going to auction. In August-ish, this is probably a violation of state law, but this is how the county does it. They conduct a sealed bid auction. So people mail in their bids and then they open them and then they award it. The state law says you have to have a public auction. It's not my area to comment on. I'm just telling you that's how they do it. After August-ish sealed bid, the successful bidder gets what's called a certificate of purchase. The collector says you have purchased this lien. That is what then starts your waiting period to see if the owner of that property or any interest holder pays off the lien. They now have to pay it back to the county with the interest rate because they're late on their taxes. And that interest could come back, if they pay, that interest could come back to you, the tax lien buyer. And if they don't pay, that's when you can foreclose on them after that waiting period. So you have this year waiting period where it's like, are they gonna pay and I'm gonna get the interest, or are they not gonna pay and I'm gonna foreclose and get the property? So that's why the end result is really a question mark when you're buying this certificate of purchase. You're not buying a deed.
Rachel, is this, I'm sorry, I just saw the title. My question was answered.
And this is also known sort of nationally, this is considered an administrative system because there is no court process involved. It's basically just shuffling papers and passing off that foreclosure responsibility to the tax lien bidder. The county's not overseeing any of that. New system, chapter 141. Collector is going to make a list of 2+ years delinquent properties. That list is going to get sent to a tax collection attorney. The attorney then files an in rem. In rem means against the property lawsuit against those properties. The county then has to obtain a title report for each property, listing every party with an interest in the property. So that's where you get all the lien holders on that property. You now know everyone with an interest. The county has to send multiple notices to those interested parties of the upcoming sale. They have to mail notice many times, and they also have to attempt to knock on the door of the property, and they have to post a notice on the door of the property. None of that is anything that happens under 140. Oh, I'm sorry. A lot of it memorized, but I can't remember what it says. Okay, the court is supervising this and a record is being created of all the notice given. That is crucial for the title insurability, because a title insurance company, what they're really looking for is, did everyone who might have had an interest in this property get a chance to redeem? Because if they think that someone didn't get a chance to redeem, then in their mind, that person could show up and say, actually, I still own this because no one ever notified me that it was going to tax sale, which they could do. It's a due process violation if you don't get notice. And a title insurance company is going to be like, we're not touching it. Someone can come back and say, I didn't get notice. They don't want to touch it. So that record of everyone getting notice is what is crucial for the title insurability. That's the record that's not being created in 140 right now. That record is the responsibility of the lien holder who purchases in 140. So some people who purchase under 140 are actually really good at creating that record and getting their title insurance. Other people are not. They don't know that they need to do that. And other people are not going to bother to do that if the property is low value. So we have all this notice given. Okay.
I'm sorry, I do have a quick question. So is this what will eliminate the properties having to go through a quiet title process? This will suffice for that?
Exactly. You can think of it as the quiet title happening before auction. Because a
Perfect.
quiet
Okay.
title is in some ways the same thing. It's an after the fact notice. It's actually kind of like a Band-Aid on the fact that this didn't happen before.
Okay.
And it's a Band-Aid that can actually only work on some things. Beforehand, you can clear almost everything. After, with the Band-Aid, you can clear a lot, but not everything. So quiet
Perfect.
title can't do as much as this can.
Okay, thank you.
So at any point in that process, anyone who got notice, or really anyone at all, though I don't know why you would do this if you weren't an interest holder, can redeem the property. They can pay the taxes and it doesn't go to tax sale. If no one pays those taxes, it's gonna go to tax sale at the same time as the 140 auction should be happening. That's the fourth Monday in August, a live public tax sale auction is what is required under 140. Like I said, they don't do that. But in theory, if they were doing that, these auctions would happen together. The point of that being that owners aren't going to be disadvantaged by going through one system or the other. Their experience of the system will be the same. And because this process, all of this notice court process, that's going to take a year. Again, the experience of the owner will be the same because then they're going to be at 3 years. Whereas 3 years immediately, they're going to go to auction. Same thing, their experience will be 3 years of delinquency. They go to auction. So we didn't want any homeowner in the county to be disadvantaged by going to 141. Okay, and then you have this auction. There's two options. It's sold at auction and the buyer has bought clear title, ready to rehab. Not sold at auction, goes to the land bank, clear title, no liens, no taxes. Okay, tax enforcement side by side. Year one of taxes unpaid. Year two, taxes unpaid, nothing's happening. Year three, 140, taxes unpaid, nothing's happening. But that's when this process starts under 141 at year three. Lawsuit gets filed, parties start getting noticed, court supervision starts, parties have the chance to redeem. That's happening continuously through year three. Year four, auction, 140, 141. If sold in the 140 auction, that 1 year redemption period starts. So even then, you're not getting title to the property yet. Under 141, you do get title at that auction. And if there's no bid, it immediately transfers to the land bank. Year five, you're in the land bank. Really, immediately after year four, you're in the land bank. But then 140, year five, there's another auction. Year six, there's another auction. Year seven, it goes on the post third list.
You're fine.
Rachel, who institutes, back on the previous one, who institutes that lawsuit? Who
Can you say
files
that
the
again?
lawsuit?
Files the lawsuit. The county's tax attorney, which the collector can choose to just use the county counselor's office, or they can choose to contract with a tax attorney. The city runs a similar process I mentioned, but it's its own chapter of law. They contract out to tax attorneys basically to run the process.
Okay, thanks.
An attorney will file that, whether it's in-house at the county or, and We've been having conversations with the county counselor's office about this too. They have their own charter requirements about when they can work with outside counsel and what that looks like. So it might be actually like a co-counsel relationship with the county counselor who also signs the lawsuit, but primarily a tax attorney is doing the work. Sort of thoughts about that are being shared and discussed. Okay, you were asking?
Yes, year 5, if it's not sold or the lien isn't sold, year 5, is the original owner still in the home, for example? Or does the county take control and they are removed from the property?
In 141 or
And
140?
140?
140, the original owner remains the original owner at all points unless and until the lien is purchased, and then that lien purchaser, if they then foreclose because they didn't pay the taxes, will evict the owner. So the county doesn't, again, like they really are outsourcing this whole process to the tax lien buyer.
So Rachel, along that same line, excuse me, did I interrupt someone? Anyway, along that same line, are we assuming all these properties are not, no residents in them, or are people living in these properties, or how's, what's the difference in the process if they're currently occupied?
Right.
Well, it's not, I would assume that that could be a part of the investigation process, if that's part of the scope of work, and the land bank can make choices if the land bank is allowed to be a landlord under law. You may not want to take on that responsibility, but that's a part of the strategic choice.
And I assume people here at this table have had experience with homeowners losing their house to the 140 system. That happens because every property, if you don't pay your taxes, is going to go through 140. Remember that you, the land bank, are participating in which properties go through 141. Highly recommend you only pick vacant abandoned properties. Like, what would be the point of putting all of this money into foreclosing on someone who's living in their house? That seems like a waste of resources and not mission aligned with what the land bank is trying to do, which is get vacant abandoned properties back to market. There's a homeowner living there trying to maintain it. It's probably not your job to foreclose, to send that to 141.
But down the road, it could be a programmatic opportunity to support families that are in legal jeopardy with their property, and the land bank could have some sort of programmatic resource to assist those families that are going to go into 140.
It's true because the 140, because you're outsourcing it, like there's no mercy. The buyer of the tax lien does whatever they want. If you keep the system in-house for those owner occupied properties, the county can have mercy and be like, let's get on a payment plan, or, we can bring your property into the land bank, clear the taxes and deed it back to you. And now you have a clean slate. Like Maude said, there's programs and opportunities. I don't know that you want that to be like your first mission, but sophisticated land banks do that type of thing. Use it as like a tax relief program. Yeah, and I don't think you want to be evicting people. Okay, where? So where does the property go? Timeline for the post-third current 140 system, that's about 7 years before you end up on post-third. New system, land bank after 4 to 5 years. Vacant properties deteriorate quickly, so the fewer years, the better. The more years you can take off the system. Title, if you're on post-third, there's absolutely not clear title. You're required to get a quiet title suit if you're purchasing off post-third. You should hire an attorney. Most attorneys recommend consulting with them before you even purchase off post-third, because like I said, the quiet title is a band-aid that can only fix so much. So there's some properties that just live on post-third because the quiet title can't fix them. The new system, you would have clear title upon entry into the land bank or at auction. Taxes, this actually is interesting. The county's policy on this is not 100% clear what they require at post-third purchases. Sometimes the back taxes, sometimes the appraised value, sometimes if it's municipality free. Other counties in Missouri will sell it for whatever they want. It's totally different and unclear. And the land bank zeroed out, you all actually decide what the purchase price is of those properties once they're in the land bank. Fair market value, the city runs a $1 program, or they don't run it anymore, but they have run a $1 program. Those are the type of things you can do. Protections after sale. So if something is sold out of post third or sold out of the land bank, post third, nothing. The county sells it and they're happy for it to be gone from their post third list. The land bank has a lot more ability to oversee what happens after they sell the property. So you can put a deed of trust, basically a performance-based mortgage on the property saying you need to perform the rehab in this amount of time or we will foreclose and take the property back into our inventory. That's a lot of work and oversight for the land bank, but you can do it. It's like a nice tool to have in the toolkit. You can require that your buyers have no other code violating property, no other unpaid taxes, that their LLC is registered in Missouri. Those are all things that basic vetting of buyers to make sure you're working with people who are actually going to get the properties back to productive use. Maintenance is a huge question mark under the current system. I think that's a big fight between municipalities, the county, the owner. Once something's on post third, it's kind of in no man's land about, and then effectively often the muni has to maintain it just because they don't want it to look the way it looks and they don't get reimbursed for that. Once the property's in the land bank, it's on y'all to maintain it. So that is a huge consideration for what amount and type of properties you choose to put through the system is, are we going to be able to maintain them once they're in our inventory? And in terms of like reputation of the land bank in the early years, I think that's going to be prominent because neighbors are going to be wanting to see that if this is a land bank owned property, it's being taken care of and the land bank is working to get this into good hands. Other post third, because of this notice stuff that is happening or not happening, that creates constitutional concerns because the due process notice and a right to be heard, that's a constitutional requirement. If that doesn't happen, there's liability that comes along with that. Because if it does happen in the new system, we don't have those constitutional concerns. Benefits of the 141 system. The legal notice, the amount and quality of legal notice is going to help owners retain their property if they want to. Because if another thing that happens a lot under 140 is just it gets mailed to the owner. A lot of people are living in the properties of someone who's deceased and they might not be checking the mail. If you are getting a knock on the door and something posted on your property, you are way more likely to understand you need to pay those taxes if you want to stay in that house. And all the interested parties are also getting notice. So lien holders, mortgage holders, there's much more opportunity to pay those taxes and stay out of sale altogether. All of that legal notice at the same, it creates an advantage for the owners and it also creates an advantage for the title. It's more insurable because all of that notice went out. It eliminates all those liens except for the federal. Faster system means the abandoned properties are getting back to market faster instead of sitting vacant, deteriorating for 7+ years. Benefits of the land bank. Again, that buyer restriction, y'all have so much more ability to vet who purchases your properties. Fair pricing, because all that tax that gets cleared, you can sell the property for whatever it's actually worth. You can use that to attract buyers who might not have bought otherwise, or the type of buyer you want. If you want to work with nonprofit developers or specific mission-aligned developers, you can price accordingly. Oversight and transparency. We are at a public land bank board meeting now. There's agendas, there's transparency. None of that happens with post third. Maybe in theory you could sunshine who's buying those properties, but it would be tough. So you all have the advantage of this transparency. You're subject to anti-corruption laws. You cannot transact with your family members or family members to the second degree. The public can and should be engaged in the process.
Rachel, on the buyer restriction, so I know you did, the youth services did this similar presentation with a few mayors in our county. Buyers cannot own other than equal or code violated properties. Now, what if a municipality come to us and they obviously own property and they qualify for that? You know, it doesn't mention anything about like government entities or I guess not.
Yeah.
I guess how would that case play out?
That's a good question. I would need to check the statute to say if it's a shall or a may, like you cannot sell to people who have code violations, or you may not sell. And the tax delinquent's not gonna be an issue because municipalities don't accumulate taxes, but code enforcement
Yeah.
would. In theory, though, this is kind of like a backdoor workaround, would be the municipality is responsible for those code violations. They could clear their own violations.
Oh, you mean like without not actually doing it? What you mean?
Yeah, like they can cite a code violation or not cite a code violation. If they don't cite it, there's no code violation. So
Dang. Well, that explains it. I mean. All right.
I don't know that I would recommend it.
Yeah.
That's the first thing that came to my head. But I imagine that there could be some kind of workaround for a municipality that wants to buy. It's not really their fault that they're owning these code violating properties. In many cases, the munis have functioned as the land bank because there was no other choice. They had to take these properties on, otherwise they were gonna sit on post third and nothing was gonna happen to them.
So is there a connection or a pipeline between municipal violations, code violations that get reported or documented in a municipality versus countywide? Like, how would we know, how would we get reports of code violations?
This is really tough. We do this in our practice because we file nuisance lawsuits, and those nuisance lawsuits depend on citation of code violations. A lot of small municipalities just simply don't have the resources to cite, much less keep track of their citations. Maybe they have someone out there citing, writing up citations and posting it on the door, but then that's it. They don't have that in a database. Sometimes they don't even do it. But there is, for sure, like if a muni is citing, the county doesn't. It's one or the other. Like either the muni asks the county to cover their citations or the muni does it themselves. So there's never like dual violation coverage. Even the county system for tracking violations, I haven't ever heard that that's goes really well, that they also have a sort of difficulty tracking what they're doing. I think that would be an amazing and huge project for if the county hires the staff person to figure out how we tighten up that system to make sure at least in the county areas, the unincorporated areas, we have good records of
Yeah.
what citations are being issued, when, by who, and for what.
Yeah.
That y'all, the land bank, could look up. Like in the city, they have a database. I can go in there, search and see when and what code violation letters went out on every property in the city. That does not, to my knowledge, exist in the county.
That does not exist.
Should exist. It should exist in every municipality. It should exist in the county.
And that state, like the city one's like really up to date too.
The city one,
Like,
yeah.
interesting.
Yeah, I would be the lag of a day or two, but most of the code inspectors are, as they input it, it's
Okay.
directly going in. And then I look.
Maybe you'll address this, but can you clarify under the county ordinance, is this land bank's jurisdiction only in unincorporated St. Louis County, or can it be invited into municipalities?
Have jurisdiction everywhere. It's countywide. That is because the county's tax foreclosure jurisdiction is everywhere. The munis send their tax bills to the county for foreclosure. They are not foreclosing their own. And because you are linked to the tax foreclosure system, it's countywide. A municipality can request, hey, don't put any of my properties on that list, that 141 list that the collector is going to create. They can ask you to not put them on there, but to be honest, Frank, you don't have to. I mean, it's completely the discretion of the county, just like tax collection is the discretion of the county. I would think you wouldn't want to do something with the municipality. You wouldn't want to notify the municipality for no reason. The municipality, I would hope, would see proof of concept and say, oh, it looks like it's actually working in these areas. Please, like, maybe take on a couple properties that we're having trouble with. Also, we know that the munis already own a ton of their own properties through post-third acquisitions. Those titles are probably bad unless they apply the title to those acquisitions after they took them into the county. To the municipality ownership. The land bank can accept donations. You could take title to those properties if the municipality asked you to. The land bank has a unique ability to file what's called a bulk quiet title. So you could file one quiet title lawsuit for many properties, whereas any other owner would have to just file one at a time. Advantage of scale, I mean, you're still gonna have to do all the individual notice for every property, but one lawsuit is cheaper and more efficient than 100 lawsuits. So there's some advantages there that you'll have as the land bank that could be helpful to communities if they ask for your help and if you chose to do that as part of your mission. That makes sense?
Rachel, I know you've made presentations to municipal league and reached some mayors, and perhaps city managers that way, but what are your thoughts about their knowing what's going on with all this? And and that might be some, a lot more education and communication might be one of the first things for this board to take on once we have our have some staff and have some bylaws and so forth. So what are your thoughts about the level of knowledge at the municipal level?
I don't know. I mean, I've definitely given some presentations to municipal mayors, so I feel like there's definitely some level of knowledge that's out there, that it exists, that it's being implemented. I do think like for municipalities, one of the big question marks is how is it going to be implemented? Because what you all decide will impact them. Like, are you going to function in municipalities or start off in unincorporated areas? So that might be a good conversation for the board to have, really to issue some guidance about for municipalities once you make those types of decisions. But I will say, like, something that comes up in these conversations is municipalities are so frustrated about the amount of resources they've invested into these properties and gotten no return on. So mowing the lawn, boarding up. A lot of that is like with a vacant and abandoned property, unfortunately, a lot of that is sunk cost. A lot of costs you're just not going to recuperate. And the main driving force should be getting the property back on the market so that it starts generating revenue again instead of sucking revenue from municipal budgets. But I always would get questions where it's like, well, when are we going to get reimbursed for the amount of work we put into these properties? So those are just conversations to have. And the long view of that property's life cycle is going to be much more beneficial than the backwards looking view of that property. Right. The summary of benefits. Owners are getting more and better notice, meaning more chances to pay off their taxes. Lawsuit, notice, court supervision, create the clear title, property sold at auction, ready to rehab, no waiting period, no extra legal fees. Properties that don't sell at auction go straight to the land bank, liens are cleared, taxes are zeroed out, land bank can sell to a new owner for the true fair market value. Non-revenue generating properties are pulled out of limbo, returned to tax productive status.
Is there any concern that the 141 system would clog up the court system, create a backlog?
That's a great question. The courts do need to be trained on this. The county circuit, the city circuit runs a tax foreclosure docket. We contacted the presiding judge like a long time ago when we first started this. We should do that again. But I don't think it will clog because it's just one suit. But it definitely will be a learning curve that they need to know about. So actually, thank you for that one. I'll make sure that conversation happens.
Rachel, as we think about community impacts, so I'm thinking about the original owner again. What is their cutoff in the land bank? So meaning they get all the notices, we've gone through the process. Is they a year from a point in time? So anytime it's in the land bank,
You own it. The original owner's rights have been completely foreclosed.
but do we have a time frame? Like, is it after the last notice?
Oh, it's upon the moment of auction. So all of that notice happens, and then there's this public auction on the fourth Monday in August. If no bidder, the second the gavel goes down at that auction, title transfers to the land bank owner, no longer has any of it.
So now they're just like any other buyer.
Exactly. But up until the moment of the auction, they can come in and pay their taxes. And in fact, in the city's auction, people do that. They show up the morning of the tax auction with their money order, whatever.
So that process is still the same.
Yeah. So up until the moment of auction. All right, steps. County passes the opt-in ordinance. Check. This actually, it says city because for the rest of Missouri it's city, but county establishes a land bank and appoints board. Check. City and county, in this case, just county, choose the properties. That's the next step. County runs that court supervised tax foreclosure system, county public auction, no bid goes to the land bank. City, again, you guys are just county, county land bank maintains and sells the properties. Tried to make the arrows about as long as I thought those steps would take, but see. Land banks are enabled by state law. Right now, the only existing ones are St. Louis City, Kansas City, and now y'all. And any other city in Missouri can now create a land bank similar to yours, a partial opt-in. St. Louis City and Kansas City have that problem that we talked about before. Okay, I have a whole slide on it. Partial opt-in. County can choose how many properties to put into the new system. STL and KC are obligated under state law to take all tax delinquent properties that don't sell at auction. That's why they have so many. Revenue sources, you all will be much better funded than KC and STL. St. Louis's city's only source of revenue is from sale of property. If you're only selling really low value properties, that's not a lot of revenue. You guys will have the 5% delinquent fee, which I'm going to talk about. $200 bidder fee. So on every successful bid at auction, there's an additional $200 fee that comes back to the land bank. And then taxes go to the land bank for 3 years after sale. This is common nationwide. It is new to Missouri that after you, the land bank, sell a property, as a reward for getting that property back on the tax rolls, the first 3 years of taxes come back to you. And then after taxing authorities, all the taxes. Yeah, so
All the 141.
141.
So if it sells at auction, the 3 years go to the land bank?
Those.
No, it's acquisition and then sale.
Yeah, because if it sells at auction, the land bank really didn't do anything. The market did that. But if it sells,
Just a bidder fee.
yeah, exactly. So just if you take title after auction and then you sell it out of your inventory, that does apply actually right now in Jackson County. I should check and see if there's been any litigation about it, because I'm gonna guess the taxing authorities aren't gonna be happy that they're not getting their money for the first 3 years, but see. Buyer restrictions, you all will have more oversight of buyers than St. Louis City's land bank does right now, which is nice. New generation land bank. So St. Louis City's is the oldest land bank in the country. Everyone knows about that. We call that land bank 1.0. Kansas City's was established around 2013, so that's 2.0. You guys are new and improved 3.0. Fewer properties, clearer title, more revenue. Those are all the things that are going to set you up for success. Fewer properties means you can be strategic. Clearer title means they're ready to go. You don't have to spend a bunch of legal fees or mess with that. More revenue means you can afford to do the things you need to do. Maintain, market, get them back to productive use. Land bank safeguards. When we were working on this legislation at the state level, due to things that had happened in Kansas City and St. Louis City, there was so much attention to making sure there was anti-corruption stuff in the state law. There was a lot of concern about that from state lawmakers. So an annual audit is required by the land bank, posted publicly. You are subject to state audit at any time, and you must make those results public, subject to public meeting and records laws. Board members and employees cannot receive any compensation for any use of the properties. You can and should consider adopting additional conflict of interest rules and ethical guidelines. You cannot transact with your own family members to the second degree of consanguinity. No elected officials can serve on this board, and board members are not by oath, but actually, no, I think you're not. Did you take an oath?
Not yet.
Actually, I think it was determined they won't have to.
They won't have to take an oath. Okay, so. To-do list.
So just a quick example.
Yeah.
What were some, you said they was concerned about corruption. What kind of corruption?
Okay, I think it was largely political in nature, because anything that like benefits urban, suburban areas, the sort of like redder side of the state lawmakers, you know, it's like, aren't they gonna do all this stuff and it's gonna be really corrupt, and it's more of like a bias than actually based in fact. But they did went to the St. Louis City, had those indictments related to the land bank of the older people. They were not actually related to the functioning of the land bank, but in St. Louis City, it's difficult to buy from the land bank without your alderperson's endorsement. And those alder people were basically being like, I'm gonna fix you up with these land bank properties in exchange for X, Y, Z. The land bank really had no knowledge or participation in that, but was implicated just because they're part of the narrative. And Kansas City's corruption scandals, I don't know as well, but I think they had something with their land bank in recent years. Yeah, to the extent the city had it, it was actually sort of just adjacent to, but not operations of land bank. But those were kind of the things people were pointing out. And when it comes to property, I think that like people do just think there is a lot of room for corruption because you can make money off of property and you can do that with your family members and friends and whatever. And that is a concern. I would say that this new system is much more highly regulated than what can currently happen under 140. 140 has almost no safeguards against that type of corruption, which could easily be happening now. So no. Okay, so that's actually kind of the extent of the tax foreclosure as it relates to land banking part of this. Do we questions, recaps, discussion points?
So we're operating under the new 141. The old is 140.
Exactly.
Gotcha.
Old is 140, new is 141. 141 is how you get properties usually.
But 140 will still be in effect.
Most likely for the vast majority of properties, 140 is still going to be what's used because it's just that select list that goes through 141. And right now, to give you a sense, like thousands go through 140 every August. So this will be not thousands. This will be a small percentage of the total universe. Maybe one day, maybe in 20 years, the majority are going through this new system if the land bank has built up capacity and structures and budget to handle that, but at first, not that.
So I'm sorry, how many parcels are on the post third estimate? I'm sure it's not 10, 12,000.
Is it 3,000? I've looked at the number many times, but not recently. And I want to say it's around 3,000 on post third.
Is this the last slide? Or,
I have a couple more, but they're just different thought processes.
when you talked about revenue, you didn't mention the potential to collect on late.
5%?
Yeah.
Okay, yeah, so part of your funding is the additional 5% delinquency costs that should be tacked onto every delinquent tax bill. We can just go to the next slide to talk about that. The county should have started collecting that upon the passage of this legislation in May. For a meeting I was in this week, they did not start doing that, but they are probably now doing that as of like Monday or Tuesday. Probably now doing that. The meeting was extremely convoluted about why it hadn't happened yet. And there was a sense in which, or there was some explanation given that it was on you all to set up your bank accounts before they could start collecting the 5%. So there was someone there from County Treasury who was like, no, we could hold the 5% until they set up their bank account, but revenue was making it really complicated. And I think at the end of the meeting, the takeaway was, okay, we're actually collecting it now and just let us know when the land bank has set up their bank account. But just to get yourselves in the best position to get that money, set up your bank account as soon as you humanly possibly can. Yeah. That is why that is the next thing on the slide, because that was the takeaway is they're gonna need your information. The sooner you can get them that information, the sooner you can get that fee. It's possible that maybe it's not getting collected until you have that bank account info. I don't think that should be the case, but it's possible. There's a lot of roadblocks thrown up for reasons that are unclear to me.
So is it still as of May or is as of whatever?
It's as of now. And they
Just
can't,
wondering how to,
they can't really go back.
Yeah.
I'm not
Do
big.
they not have to send out notice saying, hey, we're gonna start doing this, or
No.
they'll start?
No, it just gets added to the software. So now like when a tax bill gets calculated, how much do you owe? There's an additional 5% on the delinquency cost. If you pay late, you pay like 5%. So there's been also wildly different maybe you guys have heard them, estimates of how much that's gonna generate for you at the land bank from, million to like 20 million. I think we're gonna have to wait and see what that looks like. Based on what I was hearing in the meeting, like no one has really a clear grasp on that. It's just on delinquent property taxes, not on all taxes in the county. And they will need your routing number to plug into their software, and then the money, it sounds like on a monthly basis will be placed in your account. Okay, so those are, that's number one thing I can recommend. You still have bylaws to pass, right?
We do.
Staff to hire, executive director, legal counsel are both important things to have in the land bank. And then establishing your acquisition strategy, I think, is gonna be the biggest strategic project for you in your first year. That means what acquisition strategy basically means, what is that list? That 141 list that goes to the collector, what is that? Because that's gonna create the pipeline. So like we talked about, there's other ways you could acquire, like if you want to take from municipalities who want to give to you, or if you want to take off post third, those things don't depend on the pipeline. So this is the beginning, but that list, and percent will be redeemed, and percent will be bought at auction. The remaining ones, which are going to be the worst of the worst, of course, because they don't get purchased or redeemed, are going to be the ones that come to you. What and how many and where those properties are is the central question. The planning department has actually already put a lot of thought into this. Thank you, planning department. And they have worked to build some data-driven tools that can help the land bank make these decisions. Ways you can filter based on different factors, or like you have a universe of tax delinquent properties, but then you speak to this filter based on.
Yeah, they're building, so that I was chatting just like briefly before the meeting started about, what the team did. We leveraged our interns to work on it this summer as well. And they built, an ArcGIS tool using Model Builder that's basically like doing a site selection analysis. Like some of the criteria they tested were like, how occupied surrounding parcels are, proximity to different things like transit, parks, based on a lot of the parcel data. So that would, you plug the list in, and then it would filter out and say, these are the ones that meet your criteria the best. And any of those criteria could be obviously determined by the land bank, but they built that model as well.
I think a data-driven approach is going to be, you are going to get special requests from stakeholders, from council people, from the exec, being like my constituents are, this is the list, here's your list. And there's an extent to which I think it matters to respond to those types of requests, and there's a larger sort of obligation to take a strategic approach so that you can have success. Because if you're just taking requests at random, you're not concentrating your strategic approach to acquisition, and you don't know how that will turn out. Whereas if you're thinking about concentrating your investment so that you can attract developer based on, that sort of scale that you have the ability to accumulate, all of that will be important in the especially in the early years. There's the LCRA is a very different type of land holding entity in the county, but it has a horrible reputation because of how it's handled itself over the past several years and how those properties haven't gone anywhere. So I think in terms of the long-term reputation of the land bank, focusing on your early success is really important. And that will be.
I do have a question and thought on that. Do we have access to field inspectors through St. Louis County? Like, how heavy of a partnership will we have with St. Louis County so we're not duplicating work? Because I know using data, using systems, but then we still may need boots on the ground that can really determine, the properties that we are acquiring. So will we have access to field inspectors through St. Louis County, or will we have to hire them? If that's what's decided,
Right. Yeah, I think your access to them would be based on, you do not have the authority to direct them, but you could request. I mean, you could say like, hey, can the building inspectors get eyes on this list? And a good relationship with that department could get you eyes on that list, I would think, because they are still something that's in the purview of their job. Just like if a council person said, hey, could you take a look at these properties? They don't necessarily have the authority to tell the building inspectors to do that, they still might do it if there's a good relationship there.
The county also
Okay.
has monthly meetings about problem properties where they bring multiple departments together, North County stakeholders and South County stakeholders. And so if the land bank were to have staff represent at those, then staff would be aware of what properties are, or could also get on the agenda to ask questions about specific properties. So there are mechanisms and processes, relationships that are already in place that the land bank could insert itself into.
Yeah,
Okay.
I said,
Thank you.
in on excuse me, this is Joan. I sat in on a whole lot of those meetings with Public Works, and they are very, very understaffed, terribly understaffed. Don't feel they're doing an adequate job in the unincorporated areas, and they're under contract with quite a few municipalities also. But so I think we have to keep that in mind, that they're not, at this moment, they're not a great resource for us, given their own limitations, but and we can all work on that together if we have we'll have some funds to be hiring some of our own people. So I think we just need to keep that in mind. The present situation is very understaffed and overworked.
All throughout the county. So I think there's two things that could be happening maybe in parallel, which is hopefully this new system, like the county develops new proficiencies as this system occurs. And then if the land bank has the type of budget we think it will have from the 5% fee, you also develop those in-house, and that in-house expertise encourages the actual county staff to also improve alongside. Trainings. So things that I thought would be useful to you all was a title insurance industry expert who could comment on this process. We worked with them in creating the process, but I'm sure that they would come and talk to you. Perspectives from national experts. So Center for Community Progress can speak to like what land banks are doing nationwide, what's working, what's not working. Planning Department, which has created these tools that will allow you to look at properties within St. Louis County and filter them based on different sort of criteria. The Land Bank Coalition, several members are in this room, but we meet every other Friday still. We talk about what you all are doing. We talk about what the county is doing. We talk about how all these parts are going to get hopefully sewn together at some point into a lovely system working in tandem. And use our collective sort of influence to try and make sure all those parts are still moving in the right direction. I would love for them to meet all of you at some point, because there are sort of 5 years of advocacy that have led to this. And then others, I definitely can get those top two. You all can obviously get the third one at your meetings. I can get the fourth one, and if there's any other thing you would like, these are just suggestions, but I'm happy to make them happen if you want those on future agendas.
Another
Rachel.
suggestion.
Rachel, when I worked for the county, I was joining those every other Friday meetings. It would be good for the board members of this to get those invitations to sit in or not sit in on your every other Friday meeting dealing with Land Bank, the coalition. So as I said, since I'm not an employee of the county anymore, I do not get those, but it would be good for all of us, I think, to get those, depending on our.
Board members from perhaps attending those meetings because you don't want to have a quorum and be discussing matters of the board outside of a publicly noticed meeting. So if a quorum of board members attended the Land Bank Coalition, it would maybe be a sunshine problem. So I think the solution to that would be like 1 or 2 people go, just to avoid having a quorum.
Well, I mean, we just agreed that we just want to talk about the land bank.
The Land Bank Board will be discussed. I know. I've given my technical advice.
How will how would that be measured? Like, how will we know if other board members are gonna pop up at this meeting and, oh, we gotta leave because.
Well, it's similar to how when we extended the invite to the Planning Commission's work session, I asked, please let me know if you're going to attend. That way I could circumvent that issue, and it just wasn't an issue because, you know, we didn't have a lot of members attend, but you have to be really clear, and you'd all have to, in a meeting, discuss and make it super clear that only one person was attending or, you know, two people. But I would caution heavily against a quorum appearing at another meeting.
Well, that's a excellent point. Thank you for pointing that out, Mel. We certainly don't want to start out with some kind of conflicts or anything that might look like it. So, like I said, I had been attending that for years, so I would like to continue. And at some point, you know, I could ask another, you know, I could step down and ask another board member to do that if that's agreeable with folks. So yeah, so that's I'm glad you pointed that out.
An alternative would just be to notice it and to say, you know, the land bank will be meeting here at this time. That way it's just out there. That will take care of that issue. You would just want to make sure.
Robert's rules, we don't do
Right.
anything.
But I would certainly help the board navigate that. Do you have some?
A training to share that may be helpful in the future when, after you've talked with the planning department, would also be to listen to the Missouri or the Regional Home Builders Association to get a sense from them on the real estate, on the housing market in the region, to also help inform, current markets.
Yeah, I'll say that as, we at Legal Services carry out these nuisance lawsuits, which can divest owners of title, and get them into hands of new rehabbers. We do the legal process. We have learned through experience that, like, before you start the legal process, know who's gonna be at the end. Like, are there developers who are actually interested in these properties? Because otherwise you do this whole legal process and then it goes for naught if no one wants to take on the property. So thinking a lot about who your end users will be of properties that might end up in your inventory. Home builders, developers, what type of folks, neighborhood, neighbors, like how are you gonna get rehabbers for these properties? I think is something you should be working on and maybe meeting with those types of folks in the region in conjunction with putting together a list or thinking about what areas you might be focusing on.
I know that we're privileged to have both a banker and an attorney on as board members. And I thought there was some movement already to get that bank account set up. Is that starting to happen?
Give a little update. Vice Chair Dancy and I reached out to Scott Clark, who's the county's new, he's the treasurer, to ask him about where the county banks, what kind of banking relationships they have. He let me know that they have a depository services contract with Bank of America. That's where the county banks. They did go through an RFP process to set that up, and that was ultimately approved by the county council. He said that that's mostly like they also have a checking account. Maybe that is the checking account with Bank of America, and they've negotiated the fees. They get like pretty decent fees because of that contract. And then in terms of the land bank money, it is sitting in an account right now, but when there is a bank account, the process would be essentially for the land bank to be set up as a vendor. That way the county can cut a check. But he also let me know that they can do it through like a ACH transfer. That way you don't have to walk over to the bank with $1 million check. So that's the update I have. I wasn't sure if there was also investigation into how to get the like tax ID number yet. But that's what I learned from Scott this week.
So
We have to classify ourselves as with the IRS as a nonprofit per se, or is it different from your government entity?
That's what
You
I'm
can-
not sure about.
you can, when you get an EIN, you can designate that you are a government entity or political subdivision. I cannot remember the exact choice, but I have, and I know, I don't want to speak for Christina, but I know we talked about looking into reaching out to banking contacts that we had on getting information on bank accounts.
or establishing relationships. I do think that we need to decide whether or not we do an RFP or if we just solicit proposals from, from contacts we have.
Yeah, I agree. The RFP might be the easier route. I have a conversation with Commerce Bank this evening. I, of course, talked to US Bank and, everybody wants fees and all things. So, I also don't want us to be in a position where we're spending a lot of money on banking fees when I know we don't necessarily have to. So my suggestion would be maybe let's look into the RFP process just to see if that makes sense. But we'll still get to continue to have those conversations with our banking partners.
If a representative from the land bank wants to have a conversation with St. Louis Partnerships, accounting and legal team around establishing a bank account for a governmental entity, we can be available for an individual or two to talk through that process and what some of our policies and fees are. And in addition to that, and it may be a better investment at the county, with the county system. I think we bank through Bank of America as well, but we have a separate contract. But as you develop your RFP process, or do an RFP, you may want to consider doing that as an individual entity rather than going through the county's RFP process.
Oh, definitely. I don't even know if they'd be able to go through
And
but you don't
Yeah.
want to.
Well, let me just say that this is so totally out of my comfort zone. I don't want any part of it and would be very bad at it. So can we rely on, again, I said, Christina and Karen to pursue this and just keep us informed, whether they decide to go the RFP route or, just some, there aren't really that many. Well, there's lots of tiny little banks, but there's very few big regional banks that to even deal with. So, would my colleagues agree to that and have them start moving on that in that effort?
That's what we're working on. Go ahead.
Yeah, I would say I would agree too, but I think we should add a time frame to it. I think.
I believe in one of our last meetings, we said October.
Yeah.
Yeah. It may have been the last
Yeah.
meeting in
To have-
October that we would have an update in terms of where we move forward.
But not having a bank account actually.
I wouldn't put a time frame on that because we still have to negotiate with whatever bank we choose. If we go to RFP process, we have to wait for banks to submit a proposal based on what we're doing. Then we have to decide. That won't happen quickly just because banks that quick.
Legally, do we need to do the RFP? I mean, is that a legal requirement of ours?
Karen and I can continue what we're doing and talking to our peers and partners at banks and come up with proposals to present to the board and maybe come up with 5 between the two of us. And then we can go from there.
So legally, we do not need to do the RFP. We could rely on the system you're describing, Karen.
I think that is an open question as to whether or not we would legally have to do an RFP. So I can look into it. I also think we need to look for counsel as well. I do suggest we do an RFP for that.
Is there, and I'm assuming, is there a concern that we need the account sooner than later?
Not necessarily the account, because I understand the processes that will come with that, but at least the steps necessary to open up account that don't require, a lengthy process. Like for an example, like how soon can we get our tax ID number, right? How soon can we get our articles of incorporation? Because we know all of that stuff. I think we do, right?
I don't think we need to incorporate. We are already an entity. I'm looking at the SS4, the application for the EIN number. I can put together a draft and send it. Mel, I can send it to you so you can send it to the rest of the group. The box is state/local government. So I think that's what we select. Although I can't see you, but somebody was speaking about on behalf of the partnership. If there is a recommendation on not filling this out that way, I would, I'm open to discuss it.
Yeah, and since we manage, since we manage multiple boards, if you want to have a brief conversation with our attorneys or our accounting staff, we're happy to facilitate that
Is
conversation.
that how?
Pardon?
Are you with St. Louis Development
Yeah, so
Partnership?
it'll be Howell and.
Oh, yeah.
So give Howell a call, but also if you want to get some of our, what information our accounting department can share about our fees for establishing a new account that could be, legally directed towards you, and do that as a comparison to fees associated with county treasury versus going to your partners. Include that in the mix. And feel free to let me know if you need help connecting with anyone.
I think it's equally as important that we get independent legal representation.
I agree.
And that has to be done through an RFP or RFQ or something. Can we just
Shoot, we ain't got the money to pay him yet. We got the funds.
I remember one of the meetings, Jacob, I don't know, I think he has drafted a couple job descriptions, like one for the executive director. I think he may have started a draft job description possibly for an attorney. I think that would be one of the steps, because then when you do have funds, then you could just post the opening.
Well, it sounds like we have funds now, we just don't have a bank account to put them into. So, have we got people that are, again, I'm not stepping in and offering my help because I'm, way over my head on any of these issues, but both with finding our counsel and getting our bank account set up, we do have qualified board members, fortunately, to take the next steps along both of those lines. So do we have some offers of some volunteers here and some timetables?
I have written down that Ms. Dancy, you're still having some conversations with a couple other banks, and then Ms. Jordan, are you going to complete a draft version of that application? And then we can distribute that to the board members.
Yes, and I will also reach out to contacts at the St. Louis Partnership to, get to help form that application. Get some ideas from them.
Thank you.
I think right now the agenda for the next meeting, and I guess the board wants to move to old business or for the good of the order. We talk about the October 9th meeting.
I do have one question. And it is about, in looking at the materials that was sent, and this is about the training also. It kind of goes back to the training. So when we looked at the proposed bylaws that were drafted, in addition to governing provisions, they also included sections that are very operational. And so I guess my question is, when I look at sort of like the St. Louis County, was the LCRA bylaws that were presented, is there, because I assume those bylaws were provided by Legal Services. Is that correct?
First draft was done by Center for Community Progress, so that's based on their knowledge of land banks across the country.
Okay, and it was
And I-
reviewed by legal services.
And I reviewed them, yeah. Mhm.
Okay, thank you. So is there really a reason why some of those operational aspects could not be put instead in a policies and procedures manual and not in the bylaws, which really are more about governance?
Which parts are you thinking of?
So there are a lot of things in there about the actual operational and procedural, um, getting land, obtaining land, disposing of land, that sort of thing. I'm look to point exactly
Yeah.
where,
Article 8 is land bank
Arti-
acquisition and maintenance powers, Article
Yes.
8.
Article 8. And
page
I'm just,
7.
and I know that a lot of those things are straight out of the statute, so we would have to abide by them under the statute, but is it, I guess I'm thinking this is a lot of information, it's operational, it's procedural, that maybe it would be best put into a policies and procedures manual rather than a governing document.
Yeah.
And I just wanted your thoughts on that from the, and I'm sorry to put you on the spot about it,
That's
but
something- I mean, I'm definitely like, will never pretend to be a bylaws expert. Don't draft them regularly. I reviewed what Center for Community Progress does do this for land banks regularly. And all I was looking to was like, does this match our state laws? But decisions beyond that, it's up to you guys.
okay. I just wanted your input before I was like, I don't think we should put all these in here, but, because I'm looking in, okay, all right, thank you.
Well, I'll second what Rachel has said there, because I've been sitting in on those visits with the center, and they are just so knowledgeable about this. And I think if this is their suggestion, I think we should go with it. And the changes that we talked about at our last meeting, I assume they've been incorporated, and there's a new set of bylaws that incorporate those changes, or additions or omissions from our last meeting. I only have the bylaws, I only have the working draft. I do not have a complete set. I don't think any of us do. That is,
I had, I'm not sure that I distributed the version where I mostly added notes to the comments. But I can certainly distribute that. I'm not sure how much was actually like strike this, types of modifications to reflect.
And Mel, I do owe you my markup, so I apologize for not getting it. I will get it to you.
Okay, that's,
Is
yeah,
it-
that's for me.
is there any reason for us to need to adopt the bylaws today? I mean, we can defer that to the next meeting once we've got the completed, okay, yeah, okay.
I also would like to hear from Center for Community Progress since they drafted the document, just so we can ask, their thoughts and maybe get more context around some of the notes and all the things. So, I would suggest too that we.
So can I work with you, Rachel, to reach
Yeah.
out to Sarah or the
I was
appropriate?
just gonna say that I'm sure Sarah could come, or if Karen, you just wanted to talk one-on-one with Sarah, that would also be easy.
Yes.
Okay, do we need to, a proposal to defer that since it's on our agenda, or can we just agree as a
Board
group
doesn't
to
have to
defer?
take action, and since it's sitting on old business.
Okay,
Is there any general discussion?
So if I'm at a baseball game and 6 of y'all are there, What-
Yes, we have
what,
at the base. Cannot discuss
If-
business.
If there's 3,
I mean, of course not, okay. So we just gotta excuse ourselves if we see 4 other people.
Yeah, you just can't talk land bank business.
We
Right.
can be together, but we
Okay, I
can't.
just want that clarity.
Yes.
Yeah, you can all run into each other at the grocery store,
Right.
but then you can't talk about the land bank.
We have a house party, we do all that, but we can't talk about business.
Okay, I just want that clarity.
That's fair.
but it does business initiative. And everybody's got something.
Right. Any other general discussion?
For the good of the order, for the good of the order, we've had sitting in with us, the godfather and the father of this whole thing, which is the Honorable Kevin Wyndham sitting there in the background. And I just would like to invite the Honorable Kevin Wyndham to make any kind of comments he would like to, remind us of anything we're forgetting or not doing correctly.
Thanks, Joan. I know in our last meeting, we opened we presented the opportunity for the community to give comments. And so I want to open the floor for that if there's any general discussion or questions from our guests.
So my formal name is Kevin Wyndham. I reside in zip code 63.
Kevin, come up to the mic, one of the mics, please. Thank you.
63141. So thank you, Madam Chair. Thank you, John. First of all, great presentation per usual from Ms. Rachel Waterman. I would say a couple of things that my mind on the presentation, I like to speak now, is that two things that I think are going to be important generally is vision and communication. So vision means a couple of different things. It means knowing what properties you're going to buy, what the overall process is on acquiring and disposing of those properties. Also thinking ahead to things like not every 141 process is going to end up in the way. Once investors get more savvy, start going to the 141 auction.
Kevin, I don't know about Karen or Ivy, but I mean, you're coming through very choppy. Are Ivy and Karen, are you hearing all right?
It is
just me?
very choppy. Is there a mic that's closer?
I'm not
Yeah.
really sure it's the microphone. I hope.
Is this picking up? Is this picking up better now?
Oh,
That's
yes.
better.
Yes.
Okay. So, did y'all not hear any of that? Y'all want me to start over?
Start over, please.
Okay. All right. So, Kevin Wyndham, 63141. I would say that two things that stuck in my mind during Rachel's great presentation is that I think that it's going to be important for the board to have vision and communication throughout the process. In terms of vision, that not only means the properties that are going to go through the process and eventually be disposed of, but also thinking about things that will happen in the future, just kind of naturally through the process. Like not every property that goes through the 141 process is going to end up in the land bank, because once investors get more savvy and know that that 141 auction, all the liens are going to be off of those properties already, they're probably, I would say maybe even likely, are going to start buying up all those properties to where in year 2 or 3, if the land bank just consistently, let's say, has 20 homes go through the 141 process, by year 2 or 3, investors, maybe even one investor, is going to try to buy all 20 of those properties that are going through the 141 process. So I think that just kind of thinking through those things and to kind of bounce off of that communication, not only with the general public in terms of what the land bank is, what it isn't, what homes are going through the 140 versus 141 process, how the land bank is different from the LCRA and the partnership and all the different arms of government. But also thinking about not even really if the land bank wants to be in partnership with municipalities, but also even if they don't, kind of thinking through with the municipalities what the land bank process looks like. And then also thinking through what the land bank's communication process with local government, with county government even is, because the county government may seem like it's stable now in terms of the recorder isn't gonna go rogue, to use Rachel's words, but there could be some miscommunication or even some disagreement in the process, whether that be with a future executive administration, or whether that be with a recorder or director that has different views, or whether just it's a lot of communication to be had in there, I would say. So to keep it brief, those were my two thoughts. So thank y'all to the board.
I'll make mine brief. Shantae Bird, zip code 63031. The one thing that I was thinking about is the work with the municipalities. And one of the reservations that a lot of the mayors had was regarding taxes. So when the properties go into the land banks, their question was, well, what happened in terms of the municipality receiving tax dollars from that property? I don't think they fully understand that process. So in the conversations or future conversations with municipal leaders, that may be something that the land bank board wants to clarify with them, because their thought is if the land bank takes it, then that means county's taking it, and then county is going to get all of the tax dollars from that property. And then they're just going to be, without any type of ownership or revenue generating from those properties that are in their municipalities. Yeah, so that's all I had. Thanks.
I'm D'Angelo Ball, zip code 63121. Just had a question really about the board if Thursday. We talked about acquisition strategy. I was curious, I know we said a data approach was the best approach, and there will be there's a lot of relationship forming and there will be a lot of requests. I'm just curious if the board has or decided a mission strategy, a mission around the strategy, say, hey, this is our North Star. This is gonna guide us to, that strategy, or build around that strategy to say, this is our approach through the system, through a systematic approach with the data around it, but this is guiding us through that entire process every step. So.
Is there any business or discussion for the good of the order?
I still think we should make sure that somebody from the revenue office and also the county's budget office as well at least convene with us so that those formal relationships can be forged in our meetings.
Along with that, I know we're meeting every other week now, but this conversation today and all of the unanswered questions or just comments in general about our vision, where we're heading, how do we get organized? I feel like we need maybe what in corporate America we would call a retreat, maybe a Saturday. And I don't want anybody to get mad at me about suggesting that, but maybe we take a half day on a Saturday and maybe hear from some folks if they'll come out and join us and really do a maybe study session and a planning session to get some things on the board. And because I don't think we'll get that done in just a regular 2-hour meeting. We really need to dive into some things, because I know we know there are examples of land banks that we can leverage, but we have to study those and really understand what their programs and how they really structure themselves in order for us to make a decision on how we're going to move forward and even be in our first program or first group of parcels that we might want to take control over. I think we need some examples to really move forward on that. So that would be my suggestion, that we can talk with Jacob as well when he gets back around, when we can schedule that, maybe before the end of the year.
I was gonna say, with that being said, it still has to be an open and public meeting though, right?
Yeah, I think it would have to be, yeah.
Okay.
Oh, Joan, you're muted.
I have tree trimming going on my street. That's why I keep going silent here. That's very, very noisy. Anyway, Rachel, your presentation going to be available to us, your slides?
Yeah, I'll pass it.
I did send it
Already in
Okay.
your
in the meeting packet, but I can resend it as well.
Okay, and then also, Melissa, you were going to get us a list of just our own contacts and
Yes. I'll share
our
the contacts.
membership with our emails and phone numbers and so forth. Okay, thank you.
And then I would just note that the board has not determined where the October 9th meeting will happen at this time. I did look, and this room is booked. I did look into, there's a meeting room on the ground level of the of Northwest Crossing in St. Anne. I haven't like gone in there and laid eyes on it, so I can certainly do that. But the other option would be to meet at the County Government Center again as well. But the board, I think, should determine in this meeting where they want to hold the October 2 meeting.
Mel, I've been to that, Mel, I've been to that space at St. Anne's and it's very accessible. It's a good space and there's good parking right there too. So that's much more accessible than the county government building.
And also the places that I suggested, they will work only if it's planning, everybody's planning on being there in person. It just doesn't have the IT component, but if it's an in-person meeting, those places will work just fine.
Well, and that's something that would have to be checked about the St. Anne location, whether they have that capability to be virtual.
My vote is always for the county government building.
So are we saying
It's
county
right down the
government
street.
or Northwest, it's technologies?
I feel fairly certain that the technology exists in that room. I would just like to go look, or I'll ask someone there. I feel pretty certain that it does have the capabilities. And I can certainly book the space and then confirm with the board if that's what you would like to do.
That's fine. Everybody else in agreement with that?
Yes, thank you.
Purple
That'd be good.
plane if you want.
So
Okay.
you're saying Northwest Plaza?
Yes.
Okay, I will book the space at Northwest Plaza. It's on the first floor. And then I'll confirm with everyone that I know they have the technology as well.
Thank you. I know we're wrapping up, but I do have a quick question before we completely close out the meeting for Rachel, since she's here, based on what Mr. Wyndham brought up, and my mind just won't get off of it. So I need to see if you know, Rachel. So based on what Kevin said, with having the auction and it being a public auction, because I hadn't even thought about that, does the land bank have first dibs to those properties before they go to an auction? Or is there a way that we can bid on those properties at the auction to kind of eliminate or help with that situation? Because like he said, the good properties would never make it to us if we're being outbid by investors or developers.
Yes, there's so many things, and actually I was thinking about what he said after he said it too. First of all, your mission is to take on the worst of the worst. So your mission is not, well, you determine your mission, but the mission of most land banks is to take on the worst of the worst and let the market take on what the market already wants to take on. That's how most land banks operate. You do have a special power for strategic acquisition that you have what's called a deemed bid, where if you were to bid at a tax auction, either type, a tax lien auction or a 141 auction, you would only have to pay the amount above the tax debt. So whereas a regular investor pays the tax bill plus whatever it gets bid up above, you would only pay whatever it gets bid up above. Usually that is used by land banks that are trying to strategically accumulate parcels in the same area. So if you already own 3, there's like a gap and that one's going up to auction, you would deem to bid it. You wouldn't usually use just to get nicer houses. But you have that power. That's in the state legislation. The next is what I was thinking about is like, I think there must be a data approach here where you could speculate based on tax lien auctions, what properties get purchased. So like based on neighborhood, opening bid, that kind of data is there because there's tax lien auctions have been happening for years and they report out which ones sell and which ones don't sell and what they sold for. There must be a way to leverage that past data to at least project which properties will sell and which ones you'll end up with.
Okay, that's a good point. And I agree with what you said, being able to have that space, not to take the best ones, but to be strategic. Because even thinking about revenue for the land bank, like we're gonna have to consider how to keep revenue flowing in order to be a success at the same time, so. Thank you, Rachel.
Rachel, one of the things that we spent this whole almost 2 hours on now is talking about residential buildings. We haven't talked anything about commercial or office or anything like that. Is that just something way down the line to even think about?
Let's go to tax bill just like everything else.
Same
So,
rules apply.
yeah, same rules apply. I'll just say usually commercial tax bills are way higher, which might mean fewer bidders and more chance of it ending up in the land bank, but no, I think that's a great thing to be thinking about. Your strategy can be both residential and commercial. And vacant parcels too, which actually have much lower tax bills or more likely to get purchased, honestly.
Yeah, the whole idea of just vacant lots is another
It's
whole.
all stuff to think about. That feels like many steps down the road to me.
There's a lot more to learn before we get to the strategy. Yeah, for sure. But good question, so.
Yeah, and it's stuff to think about.
Anything else?
Yeah, I move that we adjourn.
Can I ask the question first? Is there a motion to adjourn?
Yes.
Is there a second?
Second.
All
Second,
those in favor?
aye.
See you in a couple of weeks, everyone.
All right, thank you, everybody. Good to see you.
Oh,